So this is going to be just a general Section 4F overview. And like I said, we'll be recording this. It's going to be a resource available statewide up on the OEM website. So this is going to cover, if I can get the PowerPoint working, it's going to cover Section 4F, like I said, a general overview. What are our requirements under Section 4F? What are the protected property types? We're going to talk a little bit about applicability and use. We're going to cover the approval options, and then Roy is going to talk over the process using some case studies. So, Section 4F refers to the original section within the USDOT Act of 1966, and it provided for consideration of park recreation lands, wildlife and waterfowl refuges, and historic properties during transportation projects. The law is codified now in 49 USC section 303 and 23 USC section 138, and it applies only to USDOT projects, and it's implemented by FHWA and FTA through 23 CFR 774. So Section 4F applies to projects that receive funding from or require an approval by an agency of the USDOT. So for us, that would be FHWA or sometimes FTA. So what does 4F require? Before approving a project that uses a Section 4F property, FHWA must determine that 1, there is no feasible and prudent alternative that avoids the use of the property, and 2, that the project includes all possible planning to minimize harm to the property. Or FHWA can make a finding that the project has a de minimis impact on the Section 4F property. So before we get into what all that means, we will cover the property types. So generally, Section 4F protects publicly owned and publicly accessible parks, recreation areas, and wildlife or waterfowl refuges, and historic properties regardless of their ownership. But they also have to be significant, meaning that for parks and refuges, comparing the availability and function with the objectives of the community, the property in question plays an important role in meeting those objectives. So in order to determine if a property's purpose is significant, you'll have to review its master plan or its management plan if they exist, or you will definitely have to consult with the official with jurisdiction, or OWJ, over the land. And the OWJs are the agencies or municipalities that own or administer the property. Significance for historic sites means the same thing that it means in Section 106 of the National Historic Preservation Act. And that means that the property is listed on or eligible for listing on the National Register of Historic Places. So in determining significance, this is one of the areas where Section 106 and Section 4F may overlap, because you have to be at least partially through your 106 process to determine if a historic site is significant. Other property types that may qualify for 4F protection include multiple use facilities, planned facilities, bikeways, trails, or wildlife management areas. If there will be a use of these properties, there's going to have to be some additional research and coordination with the OWJ and with OEM to determine if Section 4F actually applies to those properties. So when we talk about use, we are saying use within the meaning of Section 4F. And use means an adverse impact to or occupancy of a Section 4F property. And there are 3 conditions under which a use occurs. The first, more common type, is permanent incorporation, which is when a Section 4F property is acquired outright for a transportation project. 2 would be a temporary occupancy, and that for that to be a use, the temporary use of the property must be adverse in terms of Section 4F's preservationist purpose. And the last one is a constructive use. And this is when the proximity impacts of a transportation project on a property, even without acquisition of the property, are so great that the activities, features, and attributes are substantially impaired. So here, substantial impairment occurs only when the protected activities, features, or attributes are substantially diminished. So like I said, we can't approve the use of a resource unless it meets those previous conditions or if the use is de minimis. So a de minimis impact is one that involves the use of a property, but it's generally minor in nature. So there's going to be no adverse effect to the property's activities, features, or attributes. For historic resources, that would be a no adverse effect determination or a no historic properties affected determination under Section 106. If you're dealing with historic resources, you're going to be consulting with SHPO as your OWJ for the project. So the de minimis approval process is sequential and it's laid out in the PD&E manual, but generally we begin by determining if 4F applies to the property and if a de minimis approval is appropriate. Then we're going to coordinate with the OWJ and we will provide the public an opportunity to comment, and then we'll inform the OWJ of those comments and of the department's finding, and we're going to request concurrence from the OWJ with the determination of no adverse effect to the activities, features, and attributes of the property. So once we've done all that and concurrence is received from the OWJ, we can approve the de minimis use. Just a note on public involvement for Section 4F, it's pretty flexible and the requirements can generally be satisfied by the DOT's own internal NEPA public involvement procedures. And for historic sites, the Section 106 process, public involvement also generally satisfies the 4F public involvement needs. So a little bit about applicability decisions versus approval decisions. So the first thing you have to ask when you're worried about 4F is, does it actually apply? So for it to apply, a project has to meet 4 conditions. You have to have an approval from FHWA, that it has to be a transportation project, it has to require the use of land from a property protected by Section 4F, and it can't meet any of the regulatory rules or exemptions. So every case is different, and yet we stress over and over again that you have to look carefully at each property and each project to determine if Section 4F does or does not apply. So when we're making decisions on applicability, we're asking if 4F applies to the project. So those results are going to be either no use, or we can pursue one of the exemption or exceptions, and Roy's going to talk about that a little bit later. If there is a use of a protected property type, then a Section 4F approval is required. And those approvals are either programmatic evaluations, like for historic bridges, it will be an individual 4F evaluation, or it will be a de minimis approval. So now that we've covered sort of the basic introduction to 4F, I'm going to hand it over to Roy, and he's going to talk about the process with a couple case studies.
Thank you, Matt. Before we get into the case studies, I want to start with a basic slide that shows, and this slide is also a good slide to start with because it emphasizes one of the resources or one of the reference resources that we're going to recommend to you at the end of this presentation. Is that if you have to look at the type of property that you're going to be using land from, and you have to look at the extent of that use, and from that you'll initiate your starting conversations with the official with jurisdiction. And I'm going to start with a de minimis. We're going to have 3 case studies. This first one's going to be a de minimis approval for a minor transportation use of a public park. We wanted to pick some of the most straightforward situations we could that could also bring in some additional considerations. Now, you will recognize most of the points on this from what Matt already showed you, but I'm going to put it in the context of a project. So there's a couple of break points in here that I want to emphasize. As Matt mentioned, you want to start with early consideration and coordination with the official that has jurisdiction. And this will normally start at the district level, and it should normally start at the district level because the districts are in a more immediate consultation with whoever the official with jurisdiction is. Now let's say we have a public-owned park. I happen to name it Ichiku in this particular case because I'm familiar with the song. You want to look at how much land you're taking from the park and what kind of facilities you're taking from the park, and then you want to try to have some idea or get your own idea of what you want to what aspects of the park appear to make it important. You want to have your own idea of what the outstanding features, activities, and attributes of the park are before you get into a discussion with the official with jurisdiction. Now, the reason this early coordination with the official with jurisdiction is because we have I have, I should say, a preference that we always immediately try to move into a de minimis if we can. That is the preferred option. De minimis was created specifically to encourage us to pursue de minimis approvals. De minimis approvals don't require prudent and feasible avoidance alternative analysis, so they're much easier to do, even though they are more sequential than the others. So in that early coordination, we'd be looking for output from you all, or from the districts, I should say, and the official with jurisdiction. For example, if Ichiku Park has a swing set that's relatively near the existing roadway, and we have to widen the existing roadway, they may have a local code, or they may have a policy that says swing sets can't be but so much distance from a public right-of-way. In which case, one of the things we would be looking at to minimize our harm, one of the measures we could incorporate into our project is to either build them a new swing set the proper distance from the road, or to relocate the existing one. At that same point in time, we would also want to have the official with jurisdiction aware that we're going to be seeking public input. So we would inform them of that. At all times, when you're talking to the officials with jurisdiction, and especially when you talk to the public, try to speak in terms of the effects to the activities, features, and attributes of the resource, rather than immediately talking about 4F. The officials with jurisdiction are generally not intimately familiar with the provisions of Section 4F, and the public are even less so. And you'll talk to them about that opportunity for public comment so that they're aware you're going to be going to the public. And that's why I put a line on this slide here between the opportunity for public comment and the rest of the process, because normally, or it's been our experience, that most of the districts prefer to provide that opportunity for public comment at the normal point in the NEPA process. Now, there are circumstances in which that won't occur. I also put a line here because the opportunity for public comment for historic properties, let's say Ichiku Park is also historic. The opportunity for public comment for the historic purposes of the site are taken care of through the Section 106 process. And that's because sometimes there are issues in Section 106 that you cannot provide to the public without certain approvals. So once the opportunity for public comment has occurred, that's when we seek the official concurrence with the no effect of the project on the activities, features, and attributes of the property. We provide the official with jurisdiction the de minimis approval, and then we seek their concurrence. Now, in our communication for that approval, we must ensure that we state in writing that if they concur with our finding that there will be no adverse effects to the activities, features, and attributes of the resource. If they concur with it, that we will pursue a de minimis approval option. Sometimes you may want to use may pursue a de minimis approval option if you're uncertain yet as to whether or not you're actually going to do that. There are sometimes other matters related to the project that may make you want to withhold that as a definite commitment. Now it's important, one of the things I'm going to hit on, and I think I bolded it on every slide, is the project record. A de minimis can be used, unlike any other use of a Section 4F property. A de minimis can be used for Type 1 CEs or for Type 2 CEs, EAs, FONSIs, and draft and final EISs. Remember, whether you're doing a de minimis approval or whether you're going all the way to a individual approval, that it is a separate finding in our project documentation, and so it has to be treated as one. Now with the CEs and Type 2s, we're frequently using a checklist. So what you would want is on these, you would indicate what the involvement is, and then you would have backup documentation for that. And you want to ensure that that backup documentation is easy to locate in the swept project file. With EAs and FONSIs and EISs, this will come up in the narrative of those sections of the documents. So we're going to go to case study B, which is, this one's going to be a little bit more complicated because I wanted to expose everybody to this particular concept. If we have a project that's going to require either the rehabilitation or the replacement of a post-World War II historic bridge, before we get into 4F, even before we get into Section 106 on this, we want to see if this bridge is exempted under the program comment that was then extended in into the Section 4F exemption. The Advisory Council established this program comment, and it eliminates an individual Section 106 review for common bridge types of post-World War II, from post-World War II. And that's under Section 106. Now those are individual reviews. They're still considered collectively. That's a technical matter that you needn't let bother you under Section 106. And this is unless the bridge is exempted from the exclusion. And primarily those are going to be either on our state list of excluded bridges, which it can be found in our cultural resources chapter, historic and archaeological chapters, and it can also be found online at the FHW via the FHWA toolkit or straight on the Advisory Council website, because those were all published in the Federal Register. If the bridge is adjacent to a historic district, it is also excluded from, well, I should say exempted from that exclusion, or excluded from the exemption. These things get turned around, and we've got so many of them now, it's very difficult to follow them. So try not to depend too much on my language and focus on its double negative all the time on those. If it has previously been determined as significant, or if it does not fit into the eliminated categories set forth in the program comment. And the program comment is specific to common bridge types from post-World War II era. So if it doesn't fit into one of those common bridge types that they highlight, like T-beams, stringers, girders, slabs, that sort of thing, then it's not going to be exempted. Safety lieu, then the transportation law incorporated the standards and requirements of that program comment into Section 4F. So if a project involves a bridge which is exempted from individual review under 106, it is also exempted from the requirements of Section 4F. That is the approval options set forth for Section 106. I mean for 4F, pardon me. Once again, you want to record. If you've got that situation, you want to record it for a couple of reasons. You're going to want to record it in your 106 documentation so that the Florida site file is privy to that exemption applying to that bridge, and you want to include it you want to include it as a reference to your Section 4F determination that there is no involvement with Section 4F because the resources that may be in question are exempted. Now, what about the ones that aren't exempted? I took a little while to pick an example of one that was exempted, so I went with the most obvious one in our state. because it's a suspension span bridge that is definitely not a T-beam or a girder. Now, once you know you have a bridge that's not exempted from the program comment, then you need to evaluate the bridge as you would normally for National Register eligibility. Remember, significance for historic resources is based on their eligibility to the National Register. In which case, for pardon me, for bridges, we normally are going to pursue a programmatic Section 4F evaluation. Even if a bridge is contributing to a historic district, unless you're having impacts to several other resources in the historic district that are not related to the bridge or tied to the bridge, then you would be using the programmatic for that bridge. And a programmatic, I'm not going to go into details of completing a programmatic Section 4F evaluation, but I do want to highlight some of the characteristics of a programmatic Section 4F evaluation. The first element is determine that the programmatic evaluation is appropriate for the project, and that's an applicability decision. And that applicability decision is much like the applicability decisions that you make for Section 4F. Is it a protected resource? Is this a transportation project? Is it funded by FHWA? That sort of thing. It has a couple others, like if the bridge is a National Historic Landmark, you wouldn't be able to use the programmatic for it. And then you have a set of alternatives that you have to evaluate. And these pretty much reflect what you have to do in an individual as well. It's just they're very specific to what they want you to look at. In the case of bridges, you have a do nothing, build on a new location, which leaves the bridge in place, or relocates the bridge without adversely affecting it, or rehabilitate the bridge without adversely affecting its integrity. Once you've gone through those and evaluated those, and you cannot do any of them, then you begin to look at the measures to minimize harm. And the measures to minimize harm are also expressly set forth in the criteria for the programmatic evaluation. And then lastly, it has a procedure section, which gives you one of the main benefits of a programmatic, where it shows you don't have to go to the Department of Interior in Washington, because they've already read the criteria and agreed with the criteria. So if we meet the criteria, they have nothing to weigh in on. And on a programmatic 4F evaluation, that will normally always be true. For some of the other programmatic evaluations, there may be some sort of separate approval the Department of Interior has to make, in which case then they would have to see it for that requirement. And those you can look those up in the Section 4F chapter under concurrent requirements. And then you document to the and then once again, as with the other ones, you document it to the file and go forward. And for programmatic 4F evaluations, you're going to be in a Type 2 CE or greater. Now this brings us to somewhat more complicated project that we're going to use in case study C. It's only complicated because there are a lot of exceptions, exemptions, and they come from a number of different sources. They arise at different moments in time during the development of a project, and so you have to consider all that as you go forward. The timing, which is always important on these, they don't all happen at the same time, so that's why I decided that the one I would highlight first and foremost would be a temporary occupancy. Let's say, for example, you got to close off an area of a public park for a temporary amount of time. You still want to allow certain things to occur. For a temporary occupancy not to arise to the level of a Section 4F use, it has to be minor enough that it does not impact the use of the facility in a way that damages its importance. Now there's 5 conditions that we have to meet to show that a temporary occupancy does not rise to the level of a 4F use. In the photograph you see, there's a memorial to the Korean War that had, at one point, had been cut off. Fortunately, or unfortunately, I guess, for the people working on it, it was across the street from our office building. And I noticed that it had been cut off, so I went out and explained to them that they couldn't cut off access to a war memorial in a park. So they listened to me and then opened up a way for people to get in. And that's going to get to some of these conditions. Now, the 5 conditions that have to be met for a temporary, to ensure that a temporary occupancy will not rise to the level of a use within the meaning of Section 4F is, the first one is the temporary occupancy has to be less than the time needed for construction of the project. And we can measure the length of time for construction a variety of different ways. But whatever way we measure it, we want to make sure that the temporary occupancy is not longer or as long as the period of construction. And there should be no change in the ownership of the property either on a temporary or permanent basis. The second one is that the minor work should only be a minor, and the magnitude of changes should only be minor. And those would be even the temporary ones. The third one is that there are no anticipated adverse physical impacts and no interference on a temporary or permanent basis with the use of the property. That second half is one of the ones that's harder for us to meet sometimes, particularly when we're dealing with trail projects. So what we normally try to do is maintain access to both parts of the trail if a portion of the trail has to be interrupted. And for most other types of situations, this gets at the idea of access to the property. If we're having a temporary occupancy of a property, and let's say it impacts the point that the population uses to access it, well, what we want to do, or what we need to do, is offer a temporary access point for the duration of the time that we have to cut off the primary access point. And then lastly, we have to restore the lands and the property to a condition which is at least as good as that in which we found it. And lastly, there has to be written agreement with the official with jurisdiction. And that agreement does have to be written, just like the de minimis, the written knowledge from the official with jurisdiction on a de minimis. Now, there are a number of other regulatory exemptions and exceptions. And a vast majority of these can be found either at 23 CFR 774.11 or 774.13. The temporary occupancy, you'll notice the reference to that takes you to paragraph D of that section. The point I want to make about these primarily is that they can happen at different moments in time, and they are not a complete list of property types that are exempted or project activities which are exempted. Some of them, such as late designation of historic properties or late designation of properties, that doesn't apply to archaeological sites, which are important for preservation, more than for preservation in place, which means that they're important for more than the information contained. On the National Register nominations that you get from your consultants and from the State Historic Preservation Officer, you want to look to make sure that they are considered eligible under criterion D. That's the criterion for the archaeological sites that you want to see checked. If it is A, B, C, then 4F is going to protect the archaeological site. Archaeological sites also are exempted. Archaeological sites also have another exemption under Section 4F, which is that they have to, unless they're eligible under criterion D, then they are not protected by 4F. However, if you're in construction and you hit an archaeological site that is A, B, or C, then you're going to have to go through, or we're going to have to go through an expedited Section 4F process. And there's another type of, and as the title of this slide is No Use Scenarios, which includes both temporary occupancies, other exemptions and exceptions, as well as no physical acquisition of the land. But no physical acquisition of the land does not in and of itself mean that you cannot have a Section 4F use of the property. It is very important to assess the proximity impacts of the project and assess the sensitivities, or the sensitivity of any properties that may be protected by Section 4F, which might be alongside your project, but which we are not taking any land from. And real quick, because constructive use is not something we really ever want to see, but the best way to not have it arise is to simply recognize that it is not an impossible thing to have happen, that there is always a potential for a project to have the kind of proximity impacts that particular types of resource might be sensitive to. So the first thing you want to do is recognize that. Then you want to look at the properties, if you have any protected properties along the project. If there are no protected properties along the project, then you're pretty safe. If there are protected properties along the project, you want to look at those properties and decide which ones, what aspects of these properties. If you like, the same way we do de minimis and we look at the activities, features, and attributes, look at the activities, features, and attributes of that property and decide whether or not, or evaluate whether or not any of these would be sensitive to proximity impacts. The famous 25-year-old federal highway example is the amphitheater near the road, where we're going to widen it and turn it into a truck route. And the noise problem. People can't listen to Shakespeare plays at an amphitheater if there's a lot of roaring truck noise. So you want to look at what the sensitivities are. Then you want to look at the project, or we want to look at the project to determine if the project has any of those kinds of impacts. And at that point, we can compare the sensitivity and the extent of the impact, and we can state whether or not we think there can be a substantial impairment. Now, constructive use determinations are made on a net impact basis, which means that if we're going to be doing mitigation for those impacts, say it's the noise, and we put up a noise wall that mitigates those noise impacts and brings them down to a level where people can hear the plays, well then we won't have a constructive use. So it's always important to look at those. Another one is access. If we're going to radically alter the access of a facility by, say, having a large impact on parking in a certain area, then we would go and we would try to establish some additional parking to replace the parking we have to take. Now, in the statutes, I also want to bring up that some of the exceptions and exemptions that we have now are not all in the regulations. There's a few that are that are statutory. That is, they've been put into laws since those regulations are written. The regulations we have for 4F right now are a couple of laws behind. So we have some statutory exemptions, for which I can give you a couple examples. The railroad exemption is one. The rail corridor the exemption of historic rail corridors is one of them. There was also a change in another transportation law, which altered the old language about park roads and parkways being exempted from Section 4F. In MAP 21, that got changed to federal lands transportation facilities. This isn't an issue we'll have to deal with much, but it's just, I just want to make sure the rail corridor issue we will be dealing with. But I just want to let you know that the statutes are going forward and the regulations have not kept up. And then there's the ones that I'm hoping that most of us are familiar with, that are related to what is in the FHWA policy paper. That's one of the best places to begin whenever you have a question about 4F, is to go to the questions and answers section of the FHWA policy paper to see if see if it directly answers your question. The most common example for that is the air rights question, where the use of air rights does not constitute a use within the meaning of section 4F. So that one's not in the regulations, it's only in the policy paper, and there's some others that are always a matter of policy. Now, this is where we get to the references section, because this is probably the most important thing we could put into this presentation. So you'll want to make note of this slide in particular. It gives you the references you want to go to in order to get clarification on many things. As Matt mentioned earlier, we can provide you a lot of these general rules, and that's what we've tried to stick with in this presentation, is the general rules, the general application of section 4F to projects. But the general doesn't always fit every scenario. And that's why we get a lot of questions about section 4F, particularly about applicability, but sometimes also about weighing alternatives when doing analyses. And this slide has the primary ones you want to go to. We have a section 4F references and guides, which is not exactly complete right now, but it can take you to most of these other links that are up here. And all of that is very helpful. These are how I learned section 4F. I didn't learn it by just knowing the general rules. I learned it by going through project by project by project and applying the principles and the regulations in the law, in the policy paper, and so forth and so on. So I can't strongly enough emphasize the importance of this. I thank you for your time. And since I'm Roy, I thank you for your interest in Florida's highway program.